who is giving the orders. One wonders then, what is the use of having a panel if the judge advocate makes all the decisions? I want to read Article 37, subsection 5, where any question as to the interpretation of this constitution arises in any proceedings in a court of law other than appeal court martial. And I want to pause there and say this is not appeal court martial. This is a general court martial. So this section applies to this general court martial. The court may, if it is in the opinion that the question involves a substantial question of law, the court shall give any party to the proceedings requested to do so, refer the question to the Constitutional Court for the decision in accordance with clause 1. So you can refer the matter of your own accord. But when it is requested by a party, the way now we are requesting you on behalf of these two gentlemen, Dr. President and Mr. Rutali, you have no leeway. You are commanded by the Constitution to refer the matter to a constitutional court. The matters my colleagues have advanced arose in the course of your ruling, Mr. Chairman. And I will not go to the questions they have already framed. I will go straight away to a different question, the question of freedom from discrimination, in line with Article 21 of the Uganda Constitution. When there is no law to define who in Uganda chooses to bring civilians like Dr. Besige and Mr. Rutali to the General Court Martial instead of the courts of judicature, that subjects them to discrimination, and it is our prayer that this question be added, whether it is discriminatory to bring civilians to a general court martial instead of a court of judicature, especially without a defined authority that makes that choice. Because the question we are asking, who made the choice? We do not know. The judge sheet does not tell us. There is no gazette notice to tell us that XY is the one who made. We can only guess that authorities within the military decided. But it's an authority we cannot touch. It's an authority we do not know. And in a democracy, discretion and power is limited by the Constitution and laws. There is nothing in this Constitution prescribing how, who, and how the decision to bring civilians to a court martial is made. Therefore, when they are brought at the whims of people we do not know, authorities not defined, it becomes discriminatory. We want the court to answer whether indeed this is discriminatory as we state from the back. My colleagues have already argued that the fact that the offenses for which they are being tried are not defined is again something the Constitution abhors. And I've already said the Constitution exists to limit exercise of power. So if exercise of power is not limited by the Constitution, then it is unconstitutional. And the Constitutional Court needs to answer that question. I also want to add one more article of the Constitution, that Article 79 of this Constitution of Uganda, which mandates Parliament to make laws. It defines the functions of Parliament, and it says that subject to the provisions of this Constitution, Parliament shall have power to make laws on any matter for the peace, order, development, and good governance of Uganda. Except as provided in this Constitution, no person or body other than Parliament shall have the power to make provisions having the force of law in Uganda, except under authority conferred by an act of Parliament. And then finally, Parliament shall protect this Constitution and promote democratic governance. So the exercise of power to cause civilians to come to a general court martial are not defined in any law, and therefore they are unconstitutional and against Article 79. And we are asking you in framing that question, whether we can have exercise of power without or discretion without limits is unconstitutional and Article 79 to that request. Finally, everybody, including yourselves, is obliged under the Constitution of Uganda to obey it. So we are urging you to stand up for the Constitution and to refer these questions to the Constitutional Court so that we can have finality. It may be something may argue that because others have taken the questions to the court, to the Constitutional Court, they have already been answered. I want this General Court Martial to note we have raised questions that have not been raised before. There are some that may be similar to those that have been raised earlier. Questions of discrimination, questions of a lawyer who is part of the team being arrested and detained and therefore not available, questions of fair process. There are quite a number of questions that have not been answered before. Also the fact that there is nothing in the Constitution that gives the UPDF judicial authority over civilians. And therefore, any act of Parliament conferring judicial authority on civilians to the General Court Martial is unconstitutional. So it's a question the court will have to determine, to declare the UPDF Act unconstitutional to the extent that it confers judicial authority on civilians to the UPDF. And Mr. Chairman, when you are reading your ruling, you actually found that it was not, you alluded that it was not unconstitutional. The authority to interpret the Constitution is exclusively to the Court of Appeal, sitting as a constitutional court. So it will be useful even to you and the General Court Martial to hear an authoritative interpretation from the Constitutional Court as to whether you indeed can try any civilian in Uganda. The issue of extradition from Kenya, not extrajudicial rendition, not extradition. Extradition connotes a court process where orders are made. In this case, there was no court order. We urge that those issues are more than enough, and I'm asked by my colleagues that since we have exhausted, we end it here to give the prosecutor the chance to make a rejoinder.
Ladies and gentlemen, the court is adjourned for 30 minutes. Give the state for use submission of the arrest.
Who is giving the orders? Although the regulations are very clear that he gives the advice, and the court can refuse to take his advice for good reason, which must be recorded. That to us means that we, the defense, can persuade the court not to take the advice of the judge advocate when it is misleading. But it's now no longer possible in this court because it's under total control of the judge advocate. One wonders then, what is the use of having a panel if the judge advocate makes all the decisions? Right now, the court refused to grant our request for a reference to the Constitutional Court on various questions, including the question of discrimination, because bringing civilians to a court-martial is discrimination when other civilians are being taken to the courts of judicature. We also challenged the territorial jurisdiction of the General Court-Martial. Our clients, Dr. Kizza Besigye and Mr. Rutale, were arrested in Kenya. Courts of Uganda have limited jurisdiction, limited to the territory of Uganda. So we had various constitutional questions, including the question of the arrest and incarceration of lawyer Aaron Chiza, who is part of the defense team of our two clients, and his absence disables their ability to defend themselves effectively. These are very substantial questions, but the court has declined, and when we have sought to appeal their ruling, and the law clearly says we have a right of appeal and uses the mandatory language, shall. The court, through the judge advocate, has declined, and even declined to hear our arguments. We are leaving this place very sad, not able to know whether the court is still going to function or it's the judge advocate, because he has totally hijacked the proceedings.
Yes, Uganda.
The ones that you're representing, maybe begin with that. Was taken as not guilty, but yet they rejected taking.
You see, we maintain, well, our clients insist they are not subject to martial law. Yes. It's the reason they have declined to take a plea. We have persistently put across that argument. We have invoked all the relevant laws to back up that argument that our clients are not subject to military law. They are not subject to martial law, and therefore this court has no jurisdiction to try them here. So they have refused to submit to the jurisdiction of this court, and that is the reason they are not taking a plea. And it's one of the reasons we sought for leave. No, actually not leave. It's one of the reasons we had made the application to have a reference to the Constitutional Court, the jurisdiction of this court, including those matters where the Constitutional Court has pronounced itself persistently, even after the Kabazukuluka decision. Because every matter that has gone to the Constitutional Court, the verdict has been the same. The pronouncement has, and it is self-executing. We get the shock of our life when the prosecution said, we need an order of enforcement, of execution, when indeed the constitutional pronouncement or pronouncements of the Constitutional Court are self-executing. So we still maintain our clients are not subject to martial law, and this tribunal has no jurisdiction over them, and they will not take a plea before them. That's exactly what has happened today.
We hope that was recorded.
Yes?
And the plea that has been entered by that very court, because the court registered as not guilty.
Yes, it's a right for one to say, I'm declining to take a plea. And it's up to them to record whatever plea they want, whether it's a plea of guilty or not. But in law, once one declines to take a plea, they are obliged to do to record a plea of not guilty.
But they should also record that our clients refused to take plea. Therefore, the court has entered a plea of not guilty. So we are hoping that the registry will keep accurate records. The registry which the judge advocate tells us he is in charge.
So tugamba baklansi baffe bawakanya obuyinza bwa kooti eno okubawozesa mu nsonga nnyingi zonna zetayinza kuddamu wano, naye zonna nga mulabye nti kooti eno terina buyinza kuwozesa misango gye bagamba nti jazzibwa Kenya oba Greece oba Geneva, n'okuba nti babaleeta nga tebayise mateeka amatuufu ag'extradition, n'okuba nti nno kooti eno terina buyinza ku ba civilian. Ekintu kooti etaputasa mateeka kyezeddamu enkya n'eggulu entakera n'emisango gyonna ne tugireeta wano. Nekitwewunyisizza buli application gye tuteekayo dismissed, buli ke muteekayo tukagobye, so buli kye tuleeta bagoba bugobi. Awo naakula etteeka ssemateeka kirambika bulungi Article 137 nti singa oli pate emu bw'ebeesabye nti ensonga zino zigende mu kooti etaputa ssemateeka, ono bano tebalina buyinza buzigaana nazitaputa, balina buyinza buziframinga. Naye omulabi amenye ssemateeka y'ennyingo 137 ye n'agamba nti tagenda kuziwaayo, agaanye. Ekyokubiri, akawaayiro 225 aka UPDF Act kagamba nti atamatidde na nsala ye mu nsonga zonna n'engeri proceedings ezitambulamu oba omusango gye baguddukanyamu waddembe okwekubira endulu mu kooti esingawo. Ekyo nakyo agambye nakyo tugaanye. Obuyinza nga judge advocate yalagira nga senior counsel wabagambye nti judge advocate nga akomandinga bukomandinzi kakati ye yefudde amateeka. So judge advocate yeteeka kyalagira ye kati biragiro. So n'olw'ensonga eyo kiranti waffe ye bakiranti baffe bayinsistinga nti tebalina bakiranti baffe bayinsistinga nti kooti eno tebalinaako buyinza